My Lords, the question is that the Grand Committee do consider this instrument.
Yes, my Lords. For the first time, we now start to consider some of the practical effects of this controversial bill. I'll make no comment on the merits. The bill has been passed, it's the will of Parliament, and now we have to deal with the consequences. Now, the schedule of fees here provides sort of the cost of enforcement in a judicial or tribunal framework to the provisions, and we see a very large expansion consequent on the bill of the number of things that can spawn a complaint. I'm thinking particularly now about the appeal for a rent increase. Now, the lowest level at £47 provides no disincentive to bring a claim. And in fact, a single month's delay can pay for itself. In fact, I just wonder aloud whether that level, and I understand that it's important we have open to justice, but it's creating a fiscal perverse incentive to have a go. Especially, as we've heard just a few moments ago, that any rent increase would happen following the appeal and not be backdated to the point at which the appeal was made. Now, landlords are already waiting a year to gain possession, for example, in the case of non-payment of rent. And it just occurred to me that has the government made an assessment? So I asked the Minister, what assessment has been made of the likely consequential number of cases and any additional timescale and further delays as a result of these fees passing into the regulations? Will we see an avalanche of claims that will gum up the tribunal and give further incentives for claims to be made which provide an asymmetry between the rights of the landlord and the rights of the tenant?